Thank you very much, Your Honor. It's indeed a pleasure to be here this morning. Later, perhaps, I'd like to be introduced to the person that prepared that introduction. I think it's excellent, and I'm quite sure you couldn't have done a better job if you tried. My purpose this morning is to try and, in a few minutes, summarize a paper which was initially prepared by the clerks of the 4 provincial courts in metropolitan Toronto, and in particular try and highlight the differences between the procedures in the small claims court and the provincial court, and also some of the more common problems that are faced by litigants entering claims in the various courts throughout the province of Ontario. Experience has taught us that the claim form probably brings about the largest number of problems for anyone using the courts. When a claim is received in any court office, it's normally checked for several things: for content, for the proper number of copies, and for fees. Now, and supporting documentation as well. Now, when you're entering a claim, whether it be a lawyer or a collection agency, etc., it doesn't make any difference. You should be looking specifically at the following points. One, that the style of cause is set out properly. That is to say that you provide the Christian names of the defendant as well as the surnames. If it's a case of a company, the proper style of that company. 2, that you give the proper details of your claim, and again I can refer you to the example set out in the material which you have here this morning. 3, that you provide the court with sufficient copies of your claim and the supporting documents. And 4, pre-judgment interest. I'll make reference to that just a little later, that if you're going to make a claim for it, that it is set out in the pleadings. And 5, that the proper fee is submitted with the claim. This is probably the most important, and as the old Latin saying says, no fee, no sue. Now, you can probably say that, hey, this is elementary, but I'm going to tell you it's been the practice of my fellow clerks that even claims that are entered by law firms, etc., often there are no Christian names for the defendants. You'll see a claim for Jones Construction Company, and the supporting invoices, etc., will say Jones Construction Company Limited. Obviously, we're not going to question a lawyer, but it's to their own advantage to do it properly in the first instance. Usually, somewhere in the process, you'll find that an error that has been made is realized, and what will happen is that they must then proceed by notice of motion to remedy any deficiency, etc. If you're claiming pre-judgment interest in the case of a liquidated claim, it's been suggested, and the rule of thumb is that you try and compute the amount of pre-judgment interest up to the date of filing of your particular claim. In addition to this, you may also want to claim pre-judgment interest from that date to the date of payment or the date of judgment, and it's suggested that you include a per diem amount at that time. If it's a claim for damages, of course, it's only necessary to make a claim for pre-judgment interest. It should not be computed, as that will be done at a later date. With respect to the claim itself, you have to supply the court with an original plus 2 copies for each individual defendant, or 1 copy if it's a corporation or a company, a proprietorship, etc. This applies to both the small claims court and the provincial court. In the case of supporting documentation and making specific reference to promissory notes, NSF checks, etc., in the provincial court, you need only file a copy of that particular document. I'd like to point out, however, that you must file 1 photocopy for each copy of the claim. This is different from the small claims court in that you must file the original document in the small claims court. Again, the distinction between the two is that if you're unable to produce that document in the provincial court, you only need to state in your claim why you are unable to supply that particular document, and it would be acceptable. In the small claims court, it's slightly different. You have to be able to produce that document, or if you cannot, a sworn affidavit is normally the route that you would follow. This is somewhat different. Now, in the provincial court civil division, of course, you have to use the statement of claim form provided by the court. For claims $1,000 or less, which exclusive of interest, you have to use the blue form, and for claims over $1,000, you use the green form. Now, you probably think that this was designed by some bureaucrat who came in feeling hungover on a Monday morning. This is not the case at all. This was done so that we could more readily identify the claims and to be able to study the impact on the increased monetary jurisdiction in metropolitan Toronto. So therefore, if your claim is not on the proper form, it will be returned to you. In the small claims court, of course, the process for many years has been that you just file a separate or a statement of claim form, and it will be affixed to the summons that is issued by the court. One comment I'd like to make, and it's a very important point. Please, if you're filing a claim in a small claims court, don't use a statement of claim from the provincial court. The form that we use contains general information, some of which is not applicable in the small claims court. His Honor Judge Bromstein, made reference to the question of jurisdiction. I think the practice in all the small claims court in Ontario is to accept an affidavit, although you'd probably have to contact the individual court to ensure that that's the case. Only recently have we had an affidavit made available to us in the provincial court, which is normally supplied to the court at the time of filing. Now, what will happen is if the affidavit is supplied and no defense is filed, the clerk will sign judgment once the time for filing a defense has expired, provided he or she feels that the claim was entered in the proper jurisdiction. If this is not the case, the matter will be listed for hearing before a judge, and only the plaintiff will attend to prove jurisdiction. Now, obviously, if the claim is entered by a law firm or a collection agency, where, as I indicated earlier, we're only checking for content, sufficient copies, etc. An individual is at a strict disadvantage because he or she does not have the knowledge of the rules of the court. In this case, we would assist the public in that we would explain to them that they should have the surnames the Christian names of the defendant, that in the case of a company, that they should be sure that they've got the style of cause set out properly, they've got the proper name. In addition, with respect to prejudgment interest, we would also assist them with the calculation of prejudgment interest up to the date of filing of their own particular claim. We normally do not do this for law firms or collection agencies. Obviously, they have the means to do this on their own. In the provincial court, a summons remains in force for a period of 6 months, whereas in the small claims court, it remains in force for 12 months. The distinguishing feature between the two, or the distinguishing difference between the two, is that in the small claims court, the request for renewal must be made, or the renewal must be completed before the summons expires. Under the rules of the provincial court, this can be done even after the claim has expired, after the 6-month period. It's normally done by simply writing the clerk and requesting that the summons will be renewed, and the staff will attend to that. This is, I believe, applicable in the small claims court, but again, I don't know that I can speak for every small claims court in Ontario, and you'd have to contact the individual court. As was pointed out to you, the defendant has, in the provincial court, has 20 days to file a defense if served personally, or 25 days if served pursuant to Rule 19. That is, by leaving a copy with a grown-up adult in the household and mailing a copy to the defendant, or by substitutional service pursuant to a judge's order. In the small claims court, you're limited to 10 days for personal service and 15 days otherwise. Now, there is a great difference in the handling of defenses between the provincial court and the small claims court. In the provincial court, any claim $1,000 or less that is disputed will automatically be pre-tried by a referee of the court. If there is no resolution of the problem, the cases $500 or under will be listed for night court. Cases $500 to $1,000 will be listed for day court, usually be heard by a deputy judge. However, if you have parties that say are coming from a long distance, Ottawa or something like that, and the claim has been initiated in the provincial court, the matter would normally go directly to trial. An action over $1,000 that is disputed will be put before a provincial court judge for review, and normally one of three things is going to happen. A pretrial will be ordered before a provincial court judge. B, an accounting will be ordered before the referee, or C, the action will be listed for trial. In the small claims court, any action as defended will normally be listed for trial automatically. Now, in some small claims courts, we do have referees, and if that is the case, I believe that all disputed matters will be pre-tried by the referee and then on to trial if no resolution is made. Comment has been made that to Rule 29 of the Provincial Court Rules, which provides payment, along with it, or a request for payment along with a defense. This rule is not covered in the small claims court. The only distinguishing feature with this is that if the defendant admits in his defense that he owes the money or part of that money and files a financial statement, a hearing will be held before the referee. And if an order is made, and as long as the defendant does not fall in arrears of any payment schedule, no judgment can issue against that particular defendant. Another feature that is found only in the provincial court is discovery, and this is limited to claims over $1,000, as was mentioned by His Honor Judge Bromstein. If a discovery is required or requested by any parties, this is commenced by a notice of motion. You simply file a notice of motion in the provincial court, and it will be up to the judge to decide if it will be held in the terms of reference. We also have payments into court under the small claims court covered by sections 83 and 84, in that under section 83, where the defendant desires to plead a tender before action, he can make a payment along with the filing of his defense, but he does not pay the costs up to the time of filing. Under section 84, the defendant may, within the time for filing his defense, pay into court a sum in full satisfaction of the plaintiff's claim, but he must also pay the costs up to the date of filing. In either case, proceedings are automatically stayed unless the plaintiff notifies the court in writing that he or she intends to proceed for the remainder of their claim. In the provincial court, there is provision for payment into court with the defense. If the plaintiff fails to notify the court that he is not accepting it, the matter is listed for trial. This is the direct opposite to the procedure that you find in the small claims court. Should you wish to make a payment at any other time other than when you file your defense, a judge's order is required. Now, I make one suggestion to you at this time. The defense should contain no reference to the payment into court. That should be left out, and if you want to, you should use a separate notice of payment form. Applications for new trial will be dealt with. Pardon? Oh, no way. By His Honor Judge Lamb a little later. I would just like to make one point. Whether the notice of motion is to set aside a default judgment or whether it's an application for a new trial, the rules governing the times are slightly different. In the small claims court, you have 14 days plus an additional 14 days. In the provincial court, you have 14 days, but Rule 7 provides that the judge may extend the time for whatever period it may be. If you file a notice of motion and you're not within the time limit, the clerk will not refuse the motion. It will be accepted. Whether you should be going by appeal rather than by notice of motion, that's not our concern. We will accept the motion, and it will then be up to the judge to decide how that matter will be dealt with. A short comment on enforcement of judgments, and of course this is probably where you get down to the nitty-gritty. Several initial points. The rules for enforcement are identical in both the small claims court and the provincial court. That any judgment given after May the 26th, 1983 entitles the plaintiff to post-judgment interest. Where default judgment is signed by the clerk of the court, there is no waiting period, whereas if judgment is entered by a judge, there is a 15-day stay. And finally, and most importantly, no action will be taken to enforce judgment without written instructions from the plaintiff. Directions to garnishee, judgment summonses and show cause summonses will be may be dealt with later. The important part to note is that they are all commenced by filing of an affidavit. The plaintiff should be, or should make it clear to the court, if the balance differs from the court records, the reason why. If you are claiming post-judgment interest, you should state that in your affidavit, the period that you're claiming the post-judgment interest for, and the interest rate. In this way, it can be entered into the procedure records so that our records will agree with yours. In the case of a direction to garnishee, the garnishee must issue in the county in which the judgment is located. In other words, if you have a judgment in York, you must, and the garnishee carries on business in, say, Peel County, you must transcribe your judgment to the second small claims court or whatever the court is in Peel County and commence your garnishee proceedings there. With respect to judgment summons or show cause summons, they must issue in the jurisdiction of the court where the defendant resides or carries on business. If this is not the case, again, a transcript is necessary. One small point, if a committal order is granted, you must notify the court in writing of your intention to proceed with the committal order. In conclusion, I'd like to leave you with one final thought. During the course of my talk, I suggested to you that you may have to contact the individual court from time to time for specific instructions. Procedures vary from court to court, and despite the efforts of the ministry, we do not yet seem to have achieved total uniformity in the small claims courts and provincial court. We hope that we will, but as yet we haven't. If you've got a problem, feel free to contact the individual clerk. That's what we're there for, and we'll do everything possible to make your task just a little bit easier. Thank you.
Thank you very much, Rick. He didn't tell you, of course, that the line may be busy when you phone. I have the pleasure of introducing Mr. C.G. Femia as our next speaker and panelist. Some of you may have met Mr. Femia. He is the most senior in terms of a referee in the Judicial District of York, having been appointed some 10 years ago. Prior to being appointed as a referee in the Judicial District of York, he was appointed a referee of the Small Claims Court in Whitby, where he has resided since 1952 and is extremely proud of that fact. He was appointed in 1967 as a clerk bailiff in a small claims court, and prior to that he was a justice of peace, or justice of the peace. So he has a long, distinguished career in government service, and I'd like to introduce Mr. Femia now. Come forward.
Ladies and gentlemen, my name is Femia. I'm the referee. I do not make decisions. I make suggestions and/or recommendations. You make the decisions. That's how I start out. From there on, it's anybody's ball game. As many of you know, sometimes it doesn't end up the way we thought it was going to when we started. Now, from time to time, I've been asked to explain and discuss the role of the referee of the small claims courts, and when I do, I concentrate on the areas which I know best from experience, and that is the area of the Judicial District of York, which now comprises only the municipality of Metropolitan Toronto, where since 1980, claims courts are divisions of the Provincial Court Civil Division. The printed material with which you have been supplied tells why the office of the referee was first established and also describes the duties and functions of the referee, which in the Judicial District of York are many, some known, some unknown to the solicitors at large. Mainly unknown because solicitors, for the most part, very seldom get involved with actions in the small claims courts. And these functions are advising and assisting people with debt problems, assisting the courts by holding accounting hearings for actions in the small claims courts and submitting reports to the judges who ordered the accountings, answering inquiries and providing information concerning small claims courts, holding pretrial conferences under Rule 48 of the Provincial Court Civil Division. When a defendant requests that terms of payment of a claim be arranged, holding a hearing and then making an order, if feasible, under Rule 29 of the Provincial Court Civil Division. All of these are described in some detail in the papers that you've been presented. The present complement of the office of the referee in York is full-time referees, 3 full-time referees and 2 part-time referees. But since the volume of cases in our 4 small claims courts continues to increase, it is probable that more referees will be required to provide the service that is required of this office in the years to come. Attached to the advance copy of my address is a statistical report of the Office of the Referee in York for the years 1982. The report for 1983 is not yet ready, but I do have some figures this year which may be of interest to you. In actions referred to the referee for accounting in 1983, the judges of the provincial courts sent us some 943 for hearings. We held these hearings, and of that, 439 of those, which is 47%, were settled or withdrawn at the table. Now remember what I'm saying. These are at the table. I have no way of getting the totals really of what goes on between the time they leave the referee's office and the time they get to trial. I'm told that it's roughly another 25%, but I have no way of really breaking it down properly. In actions in the Provincial Court Civil Division for amounts not in excess of $1,000, there were 4,502 pretrial conferences held under Rule 48. 2,142 of them were settled, a matter of 48%. And again, I have no way of knowing what went on after the day they left our offices. The number of persons with debt problems interviewed in 83, and these are brought about by garnishment of wages in the majority of cases, were some 1,882. And we dealt with, and we wound up with getting judges to sign orders for some 1,496. Now, the procedures that we have with regards to the accountings, the pretrial conferences, have, to my mind, brought about more emphasis, I think, on the fact that people should ask for these things if they don't already have them. Because if you can settle your case in the office of the referee with an hour's time, I'm sure that it'll be far better for you, far better for your clients, and I'm sure the judges will be very happy. So think about that. I was asked the other day whether a person could or could not request an accounting of the referee because I had had a phone call. I've given it to the judges to make that decision and then let me know. Thank you.
Thank you very much, Mr. Femia. As you'll note, the next speaker and panelist is William Lynn. Bill Lynn began appearing in the small claims court in his role as a credit manager in 1962. After that, he appeared or has appeared in this particular court and the Provincial Court Civil Division in the capacity of a law clerk and, of course, in the capacity as an agent. so that Mr. Lynn's experience in this court covers some 22 years, and it should therefore be fitting that we should hear the views of this court by someone in his particular capacity. Mr. Lynn?
Thank you, Your Honor. I've been asked to address you today in respect to the role of the court agent in both the provincial court civil division and the small claims court. Authority permitting an agent to appear in these courts is conferred by way of the provisions of Section 100, which has been in effect since the turn of the century. And that section is not unique to this court in that 46 other acts, boards, and commissions also permit a party to be represented in these various forms by an agent. And Section 100, as well as permitting an agent to appear, of course, also allows for prohibition by a judge of any agent so appearing, that prohibition usually being exercised when one would be discourteous to the bench or frivolously wasting the court's time or some misconduct. Now, as I proceed around the courts for the last 22 years, I find there's a great deal of confusion in the minds of some people in respect of the differential between court agents and collection agents. The court agent who appears is not directly employed by a collection agency or is not directly employed by any one firm of solicitors. Most accounts that appear in the court, which are instituted by collection agencies, do in fact have court agents appearing for them. But the difference additionally is that the collection agency has been assigned the account on a contingency basis and of course has some interest in the eventual outcome of it, whereas the court agent who is appearing for not only collection agencies but law firms is appearing in court on a non-contingency basis and has no interest in it other than of course winning, but has no financial interest in the eventual outcome. Now, there seems to be a great deal of concern as well that most plaintiffs are represented by court agents. But statistics have proven that most plaintiffs are represented, whether it be by a court agent, by a solicitor, by a student, by a law clerk, or a paralegal, or anybody. The simple facts is that plaintiffs are more often represented than defendants. Now, you'll find that most court agents have had several years of experience in other fields, but directly related to the courts themselves. You'll find that most agents are either ex-court bailiffs, ex-court clerks, either ex-law clerks or ex-paralegals. And that, I know, pertains to both the judicial districts of York and Peel, and I suspect the same would apply to courts in other outlying jurisdictions. The court agents in York and Peel have formed an association along the lines of the Law Clerks Association, and you'll find that most agents appearing in the courts have had several years' experience. In fact, the 4 senior agents have a total of 108 years' experience, and for the most part, most agents have had at least 5 years' experience. Now, you'll find as well that most solicitors will employ a court agent to appear in the courts not only for economic reasons, the court agent appearing for a lesser sum than obviously what a solicitor can charge his client for appearing in these courts, but more particularly in the area of the night court, wherein it's mostly matters of under $500 together with judgment summonses. It's just not economically feasible for a solicitor to spend up to 3 to 4 hours in a judgment summons court attending to one judgment summons when he can employ an agent to appear who would be dealing with perhaps 10 to 12 matters. So that you'll find quite often agents appearing more frequently in the night courts and more particularly in the judgment summons courts than what you will in the day courts. Now, the court agents in Toronto and Peel cover the 7 courts in Toronto, the 2 courts in Peel, together with the various referees' offices and the various other forums where any matter originating in the small claims court is dealt with. Now, I also encounter a problem from some inexperienced counsel, I might say, that take some exception to an agent approaching them prior to the trial commencing in anticipation of effecting some form of settlement. But we have heard from both His Honor Judge Turner and from Mr. Femia that 67% of the cases which are pre-tried in some way prior to it actually proceeding to court are settled. And that is within 2% of what we have discovered ourselves, that we have found that statistics kept over the last 3 years, that we settle 65% of the cases that we get somewhere along the line. So, as I say, we'd be very close to the figure referred to by both His Honor Judge Turner and Mr. Femia. So that we approach you knowing full well that because of the length of the list, the judge undoubtedly will instruct us anyways to go outside, exchange documentation, and explore the possibilities of settlement. And some people perceive that as the agent having a per hand, so to speak, and that he's attempting to make the best possible deal from a per hand, but that is not the case. You will find that you'll be able to effect more settlements with agents. In fact, agents welcome the other party to be represented because we find that we can effect settlements more often if the party is represented by a solicitor, a law clerk, or a student. Now, mention is also made in respect of Rule 44, and you'll note that on the final page of my paper that I also refer to Section 44. I'm amazed when I go around the courts to find that not enough people, in my opinion, are taking advantage of the Section 44. If we can achieve 65% settlements prior to it ever going to trial, I would suggest to you that we can achieve a far greater percentage of settlements on these actions if we all avail ourselves of the provisions of Section 44. Thank you.
The final speaker and panelist is Michael O'Brien. Mr. O'Brien is a graduate of the University of Toronto and was called to the bar in 1981. Since that time, he has been associated with the firm of Castles Brock and is the individual at Castles Brock that's primarily concerned with the organization and running that part of the office work dealing with the Provincial Court Civil Division and the Small Claims Court. So it's with pleasure that we welcome Mr. O'Brien here this morning.
All right, can you hear me? Good. I can only think of two possible explanations for the reason that the judges have asked me to be the one to speak to you. The first possible explanation is that whenever the law brings these judges and I together, they make the wrong decision. The second possible explanation is that the judges' collective knowledge has disclosed that of all the counsel that have appeared in small claims court, I have made the most mistakes. In the rather fond hope that I've exhausted the repertoire of mistakes and that maybe I'm getting it right, I've been stuck up here before you. It may be helpful for you to know that my ability to make these mistakes flowed from an attitude toward small claims court files, which might be described as one of distaste. For these are files where the amounts in issue will not possibly justify the enormous fee that I wish to charge. There is no way that my client can afford the preparation that it probably deserves. Thus, I would tackle the file in the hope of settling it as fast as possible. If absolutely terribly pressed at the end of it all, I would get a handle on the file at trial. Thus, I'd make a lot of phone calls in an attempt to settle it. This was usually a pretty funny exercise because the other counsel had the same attitude I did and neither of us knew what we were talking about. Fortunately, of course, eventually a pretrial notice would come in and I'd drift up. I found these to be disappointing experiences. The judges failed to tell me what was in my file. The judges failed to tell me what the measure of damages was, and they very seldom knew the applicable law. Having failed to have done my job, I had to return to the office somewhat defeated and toss the file back down. Then I would get the notice of trial, as the court called it. I like to think of it as a notice to settle. I would then get on the phone and start ranting and railing. I'd try and get a few documents in. God knows we might actually be at trial. And I'd phone the other side and we'd talk about it. This was a slightly more enlightened conversation than we had before, but not much. So inevitably, it would be the night before trial. Neither of us were really ready for it, and we'd adjourn it on consent. But then god-awful days would come, and the day for the trial would actually be there. Now, of course, I predicted it. I knew my client couldn't afford trial preparation, but there we are, so I'm stuck with doing a little. My trials were masterpieces, as I'm sure the judges will tell you. My examination in chief, as I put in my case, was to say, "Witness, stand up there, tell the judge what you told me in the corridor this morning." Oh, by the way, Your Honor, I got a stack of documents here. This witness has seen them at least twice in his life, and let's make them exhibits, okay? Thanks a lot. The high point, of course, is the cross-examination, in which I would skillfully elicit the most damning answers against my case that the other side had to offer. You saw my client run the red light. I saw your client run the red light. Well, that's good. And you say he was going at 90 miles an hour. That's exactly right, 90 miles an hour. So I would retort, "Oh, yeah?" And he'd say, "Yeah." And I'd sit down, flushed with knowing that I'd punched some pretty big holes in that case. And while I was savoring that sweet victory, the judge would say, "May I have your submissions, Mr. O'Brien?" A little surprised, I would arise and say, "Well, Your Honor, you've heard my witnesses, and they're good, God-fearing people, and I certainly believe them, and I hope you do too. And, you know, you got those documents, and no question they help us out. And I read a head note just the other day that I really think speaks to this case, and I'll just mention that to you here. And by the way, Your Honor, equity is on my side." So, of course, the judge would point out that I'd failed to prove the elements of my case, had no idea of the measure of damages, the stories were incoherent, and would I please get out of the courtroom? I would explain to my weeping client as I led them out of the courtroom that it wasn't surprising, it wasn't my fault, the judge. We all know it's a political dating game where the contestants are culled from sanatoriums and homes for the cognitively impaired. It's no wonder we lost this one. Then I'd sit in my office, look at the file, and say, "There, you see, look at the dockets. I got 700 phone calls in this file, hours of time, and I can't possibly bill it." And swear I'd never go back into small claims court. Now, I know none of you have ever done any of that, but I wanted you to know my qualifications for speaking to you. Since I am stuck in the position of being here, I'll briefly mention the paper that I have included. As I have always done, I ignored Judge Bromstein's instructions. The title's quite misleading. It says "The Lawyer and How He Can Delegate Work, What He Can Do Best." That's at page 71. I'm reasonably prepared to accept that all you people can read, and eventually we'll get through it. But let me explain the theory that's behind it. It's simply this. I think certainly my practice was bass-ackwards. Do not treat a small claims file as one that will settle. Treat it simply as a trial. That's what's fun about provincial court. It is a trial. Treat it as a trial brief and gun for trial. That's what you're there for. You'll be amazed at how many settlements you get when the other side realizes all you want to do is go to trial. The other aspect, two things. The other thing is do it once if you can. When you get the file, that's when it's of most interest to you and most interest to your client. The story is fresh, and you have some idea of what it'll look like, and you have your first impression, your common sense impression of is this a winner, is this a loser? Get out your dictaphone and dictate that stuff. Get it down on one piece of paper. I've given you a structure that's used in our office. We call it a synopsis. Get it down, tie it into your documents. At that stage, you will know if you're going ahead or if you're not. If you are going ahead, I think you take the next step, which is to prepare your trial brief. The experts tell us that the way to prepare a trial is go to the very end and put yourself in the position of making submissions. In other words, at the end of the trial, what do I really want to be able to say to the judge? I want the judge to give me a verdict. The only way I can compel the judge to come to the same conclusion I did is to give them a story in a logical form, the facts of which lead irresistibly to certain conclusions, and tack it down with the law. If I can provide that, it would take a perverse judge indeed to rule against me. It's happened, but they lose on appeal. When you go through the submissions, in your mind, you see the flow of the trial, what you have to show and when you have to show it. Again, my paper sets out a suggested checklist for that. But here's where you can now start to save some money. You've gone through, you know what you have and what you don't have. Then what you don't have somebody else do. Now, I'm not going to tell you whether to use a clerk or a student or a secretary or your next door neighbor. You know those people, I don't. But understand that in this court, every person can do everything. And it's for you to decide who best can do that at the best rate. It may well be your client should present their own case. But since you actually have written a checklist of who's going to prove what and say what when, your client can do that. And they will understand why your pleadings are the way they are. That will allow you to reduce some fees. 2 points I want to leave you with. I'm going to be stronger than the other speakers have been on these 2 items. In this jurisdiction, the most important rules, in my view, and the ones that have to be remembered, are number 1, the rule about documents. It's great. You can, simply by sending your documents to the other side, have them in evidence. I give the documents to the other side at the first opportunity. If I can attach them to the claim, I do so. The rules actually say you have to in some instances, but I'll attach anything if it looks good to me. If not, I will deliver them with a big smile to show what a friendly guy I am. I'm giving you my whole file, I say at pretrial. And then I go to trial and say, I have no witnesses, that's my evidence. And the other side goes, what? Well, you see, there's this rule that says that's all in evidence, and you're stuck with it, and that's my case. So by being very friendly, very open, and a very courteous counsel, you can save yourself a lot of money. Do not waste that opportunity. Also, on pretrials, because you know what your trial is going to be like, because you pictured it in your mind in the first place, you will get at pretrial what you want, and you can shorten the trial. You know the way you want it to go, you know the things you want agreed, and you know what orders you want from the judge. The other side doesn't. They're still thinking, God, I hope I never have to take this to trial. Finally, I will say this. The written offer to settle, Rule 44. I will go further than anybody else. If you walk into a trial without having served an offer to settle, I think you're verging on incompetence. If you don't know what that file is worth 20 days before trial, you shouldn't be going to trial. It's that simple. Since you have the opportunity of belting up the costs by double, it may well be that you can actually prevent your client from having to dip into your brilliant recovery to pay your fees. And I'm sure I'm over time, and I thank you. I know that I had to talk and you had to listen, and I hope we finished at the same time.
In order to keep on our tight schedule, because we intend to finish at 1 p.m., in view of the fact that we're 2 minutes, approximately 2 to 3 minutes to 11 o'clock, which is coffee break time, I would make 2 suggestions. One is that during coffee break, please feel free to discuss any specific questions with any members of this panel or anyone else who is speaking or who will be speaking between 11 o'clock and 1 p.m. Secondly, of course, if you have any written questions, please bring them up before the break. And hopefully, and thirdly, perhaps during the time period between 11:41 and 12:20, the panel that will be meeting later on will have an opportunity, or perhaps a fuller opportunity, to discuss some of the questions that you've raised.